Hello, my name is Teresa Spahn, and I'm the presiding judge of Denver County Court. As a new judge, one of the more challenging responsibilities you will encounter involves sentencing defendants who've been convicted of a crime. While most of us were familiar with the rules of evidence prior to joining the bench, few of us had experience in removing the civil rights of our fellow citizens. With so much at stake, sentencing is obviously a task we want to perform well. The purpose of this benchbook video is to provide you with a basic understanding of the sentencing process for any criminal case in county court. I will begin by framing the overall purpose of sentencing as set forth by the Colorado Legislature in CRS 18-1-102.5. When imposing a sentence, judges must weigh and balance 6 specific and at times conflicting objectives. 1, to punish the defendant in relation to the seriousness of the offense. 2, to assure fair and consistent treatment of all defendants. 3, deter the defendant and others from future criminal activity. 4, promote rehabilitation. 5, employ and incorporate evidence-based practices, and 6, accommodate restorative justice concerns. As you can imagine, combining all of these goals into a single appropriate sentence is not always easy. Not only do you need to balance the mandated goals, but you must also consider the position of the defendant and the victim and society's interest in safety and justice. Next, we'll look at the sentencing objectives in more detail. This will not only help you to determine an appropriate sentence, but it will also help you to develop a framework for explaining your decision on the record at the end of the trial or at the end of the plea. The first goal of sentencing, and the one that many in the lay community believe is the primary goal of judicial sentencing, is punishing an offender for violating a statute. When weighing punishment factor as part of a sentence, I typically begin by looking at the gravity of the offense as well as the type and amount of injury caused to others. As a judge, it's your responsibility to determine what appropriate punishment should be. The next objective is fairness and consistency. That goal sounds easy. I mean, what judge doesn't want to be fair and consistent? However, as with most aspects of sentencing, there are often competing interests within a single objective. For example, on the one hand, the court will consider the background, situation, and needs of the defendant before you. On the other hand, justice is typically best served when similarly situated defendants receive relatively consistent sentences. For a judge, the most important requirement is clarity. If you have a defendant whose culmination of facts and circumstances cause you to deviate from a typical sentence, make sure the findings used to support your decision are clear and specific on the record. For example, if you're imposing a harsher sentence than is typical for a crime, you will want to clearly describe the aggravating factors behind your decision. If the sentence is more lenient than usual, describe the mitigating factors involved. Of course, as a new judge, you may not know what a typical sentence for a particular case in your jurisdiction is. For example, what is a typical sentence in a first-time DV non-aggravated case? How does that compare to a defendant who stands before the court on a third DV incident? Do not be afraid to ask your colleagues for help. All of us have been in your shoes. Judicial Canon Rule 2.4 allows a judge to consult with any other judge on pending matters. While the extent of those consultations should be limited to aiding the judge in reaching a final decision, the ultimate decision is yours. If it makes you feel better, you will find that even experienced judges sometimes consult with their colleagues on cases with unusual facts or laws. Another situation in which a judge may see a deviation involves a stipulated sentence in which a sentence agreed to by the parties appears to stray from a typical disposition. What should you do in this case? Well, in a word, inquire. As a judge, you have a right to reject any agreed upon sentence, but the only way you can make this determination is to identify the circumstances upon which the stipulated sentence was based. In more cases than not, you will find that the sentence was based on circumstances that support the deviation. However, it is your statutory obligation to make this determination, which you cannot meet without obtaining sufficient facts. The third legislative mandate, sentencing as a deterrent, is more complex than this short video could possibly cover. A number of studies have been conducted on the deterrent effect of sentencing, and most have found little or no relationship between harsher sentencing and reduction in criminal activity. In fact, evidence shows that exposing first-time offenders to too much punishment can increase their exposure to criminal behaviors, thereby increasing the likelihood they will commit subsequent crimes. While the severity of punishment may not deter recidivism, research indicates that the certainty of punishment, the fear of getting caught, may discourage future criminal activity. One of the best examples of sentencing being used as a deterrent is in the increasingly harsh sentences given to DUI offenders, particularly repeat offenders. Many in the public are aware that a DUI offense carries stiff penalties. In this case, the intent of the law appears targeted to two groups: the defendant standing before you and members of the community who will hopefully be dissuaded from committing similar offenses in the future. The fourth sentencing goal, rehabilitation, has gained increased legislative and judicial attention in recent years. Today, not only are courts required to consider rehabilitation in sentencing decisions, rehabilitation is often considered one of the most effective methods of preventing future criminal activity. This increased focus on rehabilitation has also been a catalyst for a dramatic increase in a number of problem-solving courts in Colorado. Today, there are over 55 operational courts in the state addressing the needs of offenders with substance abuse and mental health problems, many whom are military veterans. With judicial's increased emphasis on rehabilitation, it may be helpful to educate yourself on services and treatment options available in your community, such as substance abuse treatment, anger management, mental health services, and others. The increased emphasis on rehabilitation goes hand in hand with our fifth objective, evidence-based sentencing. As you're probably aware, the trend in Colorado and throughout the nation is to employ and incorporate evidence-based practices into your sentencing structures. This trend only makes sense if we want to encourage objectives such as fairness, deterrence, and rehabilitation. We need to use procedures that have proven to be the most successful in meeting those goals. A good example of evidence-based practices in Colorado is the relatively recent implementation of a new treatment model for domestic violence offenders. Prior to 2010, Colorado required all DV offenders to participate in a minimum 36-week program, regardless of the offense or the offender's criminal history. Beginning in 2010, Colorado began implementing evidence-based principles. After an individual was convicted of a domestic violence offense, treatment providers obtained data and evaluated the offender against 14 empirically determined risk factors. The defendant was then designated low risk, medium risk, or high risk for recidivism, and assigned a treatment program appropriate to that level. Today, the length and elements of a treatment plan depends on whether the offender is achieving his or her specific treatment objectives as opposed to attending classes for a specific amount of time. As a judge, you will review an individual defendant's situation and then determine the level and length of supervision needed to address those issues. This is not always an easy decision, particularly for a new judge. My primary recommendation is to carefully listen to the arguments from both sides, consider the professional recommendations, if any, and make your decision. When discussing the first sentencing objective, punishment, I told you that I examined the seriousness of the offense as well as the injury it caused. Those same elements are relevant to restorative justice decisions. For those not familiar with them, restorative justice is an innovative sentencing approach in which courts may consider, in conjunction with sanctions or incarceration, the impact on the victim and the defendant's willingness to repair the harm they caused. Restorative justice is not for every case and must be at the request of the victim. In general terms, restorative justice requires the defendant to accept responsibility for their actions, exhibit contrition for those acts, and be willing to take tangible action to repair the harm caused. If a prosecutor or public defender or defense attorney informs you that a victim and defendant have expressed an interest in participating in restorative justice as a partial solution to the case, you will initially consider the impact on the victim. If you believe a restorative justice remedy is appropriate, you will typically ask the defendant to accept responsibility for their actions, order them to pay restitution, write a letter of apology. With respect to the community, defendants are often asked to perform useful public service and/or participate in a victim impact panel. That concludes our review of the objectives that judges are required to weigh and balance during the sentencing phase. While it may appear a bit overwhelming at first, finding that balance will become easier with experience. In the few minutes we have remaining, I'd like to briefly review the general procedures in which a sentence is imposed in most county courtrooms. First, you as a judge must decide if the court should proceed to sentencing immediately or set over for a sentencing hearing. In minor cases such as traffic offenses and lesser crimes, judges generally impose the sentence immediately after accepting a plea of guilty from the defendant or immediately following a guilty verdict from a jury. If a case is more serious, such as a sex offense or one involving domestic violence, you must decide if you should order a pre-sentence report, commonly referred to as a PSI. Ask, is it necessary or appropriate in this case to order a PSI? And consent from a surety is needed if you decide to continue the sentencing. Otherwise, the defendant must be taken into custody. The actual hearing. 2. Ask both sides if there are any additions or corrections to the PSI that they would like to put on the record, and ask if either side is planning to have the court consider additional evidence. 3. Allow both sides to make argument and present evidence. 4. Allow the victim to address the court pursuant to the Victim Rights Act. 5. The defendant has a right to elocution. Make a statement to the court. After defense counsel has made extensive argument, every once in a while, the court forgets to give the defendant the opportunity to address the court. So make a note to always ask if there is anything the defendant would like to state to the court, or the sentence can be overturned. 6. Restitution. Ask if restitution is requested, and if so, if the defendant is in agreement with the amount, or should that be set for a later hearing. The defendant has a right to reasonable restitution, and that is better addressed at a short subsequent hearing. 7. The judge imposes sentence. You have to explain your sentence and include in your findings the defendant's unique history and facts, including mitigating factors, aggravating factors, extraordinary factors, likelihood of rehabilitation versus recidivism. Check for and address the statutory considerations, if any. Probation versus jail. Remember to think about credit for time served. Financial matters. You have to impose fines and costs and restitution. And any other required findings, for instance, in DV cases.
Thank you. Please be seated. Good morning. The court is going to call 16 GS 3459 at this time. People of the State of Colorado versus Bill Haney. The court would start by asking for appearances for the record.
Good morning, Melissa Annis for the people.
James Oval on behalf of Mr. Haney, who appears to my left.
Thank you. The court has received the pre-sentence report. The court has had the opportunity to review it. I'm going to turn to the prosecution first Counsel, are you going to receive the pre-sentence report?
I am, Your Honor.
Are there any additions or corrections?
Not from the people.
And will you be providing any additional evidence today?
No, Your Honor, just argument.
All right, and the victim is present?
Yes, Your Honor. Ms. Archuleta is present with the victim advocate.
All right, and will she be addressing the court today?
No. Your Honor, she would not wish to address the court.
Okay, if she changes her mind, just let me know. Counsel, I'll turn to you at this time. Will you be introducing any additional evidence besides argument or statements by the defendant?
No additional evidence, just arguments and mitigation.
All right. All right, the court at this time will turn to the prosecution for any argument. If you could please approach the podium.
Thank you. Good morning, Your Honor. Your Honor, I know you've reviewed the probable cause. I know you've reviewed the PSI, so I will keep this brief. I know this is extraordinarily aggravated. There were children present. This is a third conviction for Mr. Haney with the same victim. Your Honor, she has asked me to relay to the court her desire that you do not allow him to participate in treatment again, but rather that you keep her safe by incarcerating him. Treatment has not worked in the past. It will not work in the future. He is a danger to Ms. Archuleta, and he should be incarcerated.
Thank you. And did the victim decide to make statements, or she still stands?
She would not like to address the court at this time. Thank you.
Defense, the court will hear from you at this time. And before we get started, will your client be making any statements to the court?
A very brief statement, Your Honor.
All right, thank you.
May it please the court, Your Honor, Mr. Haney stands before the court very humbled and extremely remorseful about what has occurred now for the third time. He takes this case and these charges as seriously as he possibly can as it relates to his life and his wife's life, and he realizes the great harm and hurt that he has caused Ms. Archuleta. For this, he feels terrible. And that feeling makes him want more than ever to rectify these problems by getting the treatment that is necessary to give him the skills to no longer appear before this court in this fashion. So we are asking the court to consider granting him the longest possible domestic violence treatment program that the court can order. He will, of course, follow any protection order terms that the court deems appropriate. And we ask the court to suspend a tremendous jail sentence based on him following through and complying with the probation terms that the court would see fit. Mr. Haney would also like to address the court at this time. Mr. Haney.
All right. Mr. Haney, anything that you'd like to state to the court?
I would like to say I'm very sorry, Your Honor, and I take full responsibility for my actions.
All right. The court appreciates those comments. We'll take those into consideration. Well, this is what I'm going to do. I've heard argument from your counsel. I've heard argument from the prosecution. I've taken into consideration the victim's statements as well. This is the third time for you. We've tried treatment that doesn't work. Nothing has worked. Not to mention, once this case was filed with this court and was pending and there was a mandatory protection order in place, you violated that mandatory protection order. It is for those reasons that the court finds that a jail sentence is appropriate in this case, and a lengthy jail sentence.
Again, welcome to the county court bench. Effective sentencing is one of the most important and challenging responsibilities of any new judge. By keeping the fundamental objectives in mind, you will be able to tailor your sentences to the specific defendant in crime while recognizing the impact on the victim and the community. And remember, we are here to help you. Good luck.